Good evening, everyone. My welcome to the Garden Court webinar on personal welfare deputyship. What next? That I would firstly like to welcome and thank everyone for joining myself and Alex on a Thursday evening, especially when it is sunny outside. So, as you say, this is a seminar brought on behalf of Garden Court's Court Protection team. In this webinar, we seek to explore and gain a bit of an understanding of the three recent Court of Protection decisions in respect of personal welfare deputyships. Those are the case of Re-PAR, Re-HDEB 2026 and Re-XY 2025. As I've spoken to a number of people about these cases, and it's kind of like when one comes, like London buses, they all come at the same time. We will also seek to discuss and explore, does the collaborative and informal decision-making process envisaged by Section 4 and 5 of the Medical Capacity Act actually work? Should there be an exception when considering those who've never had capacity? And is there a requirement for better guidance for social care and medical professionals? And if we get to it, what next? My name, as an introduction, is James Holmes. I'm one of the conveners of the Court Protection team. I've been a specialist practitioner in this area now for about 5 to 6 years. I also practice in family, and I also sit as a nominated judge of the Court of Protection, but all matters and comments that I make during this webinar is my own professional capacity as a barrister, does not reflect anything from HMCTS. I regularly appear in Court Protection on all matters in front of Tier 1, Tier 2, Tier 3 judges, ranging on issues of personal welfare, Section 16 and Section 21A matters. Accompanying me this evening is Alex Temple. He's a barrister specialising in public law, discrimination, human rights. He has an extensive experience in education, community care, policing and criminal records, which gives him a great perspective when he comes and deals with matters in the Court of Protection. Alex also often advises children and vulnerable adults in cases arising from schools, colleges, exam boards, universities. He acts regularly in claims for judicial review and EHCP appeals and money claims. And this all brings very, again, useful perspective to all matters that come in the Court of Protection. So Alex is going to give summaries of those three cases first, and then I will touch upon the other questions. So over to you, Alex.
Thank you so much, James, and thank you for myself as well for everyone joining. I've been given the nice and straightforward job of doing the case summaries, which means I don't really have to put my own independent thoughts on the line by expressing any kind of potentially contentious opinions, which I'm very grateful for. If I could have the next slide, please. Thank you very much. As James said, we've got three cases to discuss today, but before that, we need to set the scene with the 2019 case of Lawson, Mottram and Hopton regarding appointment of personal welfare deputies, which I'm sure will be familiar to yourselves and most of you already. In very brief, it's going to set out the principled approach taken in 2019 to the appointment of personal welfare deputies. So the case concerned, of course, the appointment of deputies for three applicants, three mothers, each seeking to be appointed as deputies for their children who were aged between 20 and 24. So not so distant past, they will have been children under the age of 18 for which the mothers each had parental responsibility. And what the court had to do is consider the code of practice, the statutory scheme and the case law, and in essence decide whether or not to start with there was a assumption in favour of refusing application, so I suppose an assumption against appointing personal welfare deputies. Can I have the next slide, please? Thank you so much. So it looked at, again, to start with the code of practice, which suggests that the appointment won't be made save in the most difficult cases. But the court, having assessed that and the statutory scheme and the case law, came to a different conclusion. To the extent that the code of practice states or suggests that there is an assumption against appointment, there isn't one. Nor is there a starting point by which you can begin with either that a person will or will not be appointed. It is simply the case that each matter is going to be decided on its facts and on its merits, accounting for all relevant circumstances and what is in P's best interests. Again, P's wishes and feelings are to be considered in the decision. And whilst the appointment might be rare, its rarity is not an indicator of any kind of judicial predisposition against appointment in the first place. The court said that it is a distortion to regard the appointment of a personal welfare deputy as in any way less restrictive as of an option than the collaborative and informed decision making process envisaged by Section 5 of the Act. Can I have the next slide, please? Thank you very much. So that was 2019. And then we get to the first of our three cases in 2026. And this one is Parr v Cheshire East Council and another. So we might say that where Lawson and Mottram was principled, this is pragmatic. The case concerned an 18-year-old Ruby Parr, for whom reporting restrictions had been lifted, whose mother had struggled extensively whilst Ruby was a child to secure decisions in a timely and effective manner, particularly where those decisions involved multiple agencies and multiple statutory bodies who were involved in decision-making for Ruby. She therefore sought, after her 18th birthday, given those difficulties continued, and yet after her 18th birthday, of course, she could not point to her parental responsibility, she sought to have herself appointed as welfare deputy. Ruby was non-verbal, peg-fed, and had epilepsy with sometimes over 30 seizures in a particular day. In fact, often over 30 seizures in a particular day. So very, very considerable individual needs and a huge amount of complex work going into making sure that her best interests were protected and advanced and her welfare protected. The court noted that Miss Parr, Ruby's mother, was able to work collaboratively with professionals. In fact, it had nothing but praise for her. And as we'll get to in a moment, so did other professionals around her. There was a huge amount of consensus that she was an appropriate person to act in Ruby's best interests. Can I have the next slide, please? Which I think is just a wall of text slide, I'm afraid to say. Yes, there it is, wall of text. But the reason that I've quoted this paragraph 37 of the judgment in full, and I'm sure you'll be dismayed to hear going to read it in full, is because this is where essentially the principle is. And this is what the commentary is generally considered to give rise to the view that this was a shift toward a pragmatic rather than principled approach, where the principle, of course, was about the promotion of an individual's or P's autonomy and individual decision-making where possible. It reads, a personal welfare deputy is not needed merely because a child with complex needs becomes an adult. It is unlikely to be appropriate if there is a single significant decision to be made. In most cases, the appointment will not be required, but in some it will. Here, there is likely to be a series of decisions to be made about Ruby's health and welfare. In the first few months of Ruby's adulthood, Miss Parr has experienced further incidents of that kind, and that kind, of course, being those difficult situations they had before she achieved the age of majority, but without the ability to point to her parental responsibility and give weight to her views. Difficult decisions lie ahead, and whilst there may be agreement amongst all involved, there also may well not be. It is also in the experience of this court that public bodies and others responsible for the care of an adult without capacity are anxious about having the appropriate consent for certain interventions or about the propriety of sharing information. It would be invidious to insist upon repeated applications to the court to resolve these matters when the court can be satisfied, as I am, that Miss Parr is uniquely placed to assess and act on Ruby's best interests. Next slide, please. Thank you very much. As I said before, support for the application came from Miss Parr's ex-husband, who was Ruby's father, and who visited about 4 times a month. Support from other professionals, close family members, and those who care for her professionally, said there simply wasn't dissent about her appropriateness to be appointed. And again, the court went to lengths to praise Miss Parr's commitment and capacity, and had no doubt that she was acting in Ruby's best interests. The court considered whether or not a deputy is a more restrictive approach than the collaborative approach of the court, and said the appointment of a deputy would not take away any autonomy from Ruby because she cannot exercise autonomy in relation to anything except the most basic activities and needs. I would not view the appointment as being restrictive of Ruby's freedoms or right to self-determination, to extrapolate from that, because her capacity for making decisions for herself is already so extremely limited. And that's going to be at odds with the next case we cover, and hence there's been a bit of a split. The application was granted. However, the judge noted that his judgment was not an inducement to others to make applications for appointments as a personal welfare deputy in cases where appointment would not be appropriate. Next slide, please. Thank you so much. So here's the second 2026 case. And this one is where there's a departure, and I'll talk in a moment about what this potentially means. And it was one that the court noted, and His Honour Judge Beckley, excuse me, granted permission to appeal after refusing the application for appointment at the end. So really similar circumstances. This case involved a 22-year-old man, HDEB, and the applicants wanted to be appointed as welfare deputies, of course. And just like in Parr, the judge was at pains to describe his admiration for the jobs that the deputies had done and said no parents could have done more for their child than JB and SB have done for HDEB. But he said that HDEB's disabilities may mean that he is less able to exercise autonomy than a non-disabled person, but that does not mean that his right to autonomy should be any less jealously guarded. And regarding parents' involvement, said it is virtually impossible for decision makers to claim that it is not practicable and appropriate to consult JB and SB given their love and knowledge for HDEB. I'm not sure that all of us would necessarily agree that that commitment from parents means that it's always practicable to be consulting on every decision made, but that's the view the court took. Despite having sought specific witness statements from HDEB's parents on that specific matter of difficulties in bringing the views of multiple parties together, parents and statutory bodies, and reaching collaborative decisions, which had, just like in Parr, proved to be difficult. Can I have the next slide, please? Thank you very much. However, the court did say that, in my view, the examples given by JB and SB demonstrate how collaborative decision-making can work and has worked for HDEB in his best interests. Often it isn't simple and straightforward, but when decision-makers have taken JB and SB's views into account, as they must, along with their own professional knowledge and experience, the right decisions appear to have been made. And so it cannot be practical for parents to make day-to-day decisions, such as to diet, dress, leisure, and social activities. So the application was refused, but permission to appeal granted because the judge, in his words, says, I recognise I've come to a different decision in this case than Justice Poole did in Parr, despite the circumstances of HDEB, JB and SB having similarities to those of Ruby and Alice in Parr. So there's a split in opinion between that pragmatic approach and that principled approach, leading to a difference, a night and day binary different outcome, and an appeal pending, it seems, or likely to be pending. Can I have the next slide, please? This is the third and final case. This is XY. This case is not about appointment of a deputy. It's about deputies having already been appointed. It's about the scope of their powers and to make decisions, specifically in two ways. Whether or not the court should take a maximalist approach to the interpretation of orders granting personal welfare deputies authority to make decisions on behalf of P. And second, whether or not when a deputy is appointed and is willing and able to make decisions under the powers for which they've been appointed, whether or not that precludes the court from making best interest decisions that the deputy is willing and able to make. So it concerns XY, who was a 29-year-old man with a range of diagnoses, including autism and ADHD. There were concerns that his social media use were putting him at risk, including posting racist messages and sharing his full name and address online. The order that had granted his parents and brothers deputyship had described that they would have powers to make decisions about his leisure activities, but not specifically included social media use. And so they argued that it extended to the making decisions regarding his social media use. Can I have the next slide, please? Thank you very much. The first decision of the court was that XY's internet and social media use did not fall within the scope of the personal welfare deputyship order. So there will be some practical guidance in just a moment from the court about very careful need to ensure that when making applications for deputyship and describing the kind of decisions that are sought to be included in the order, that specificity is brought, and there is no reliance on generality, because actually the application or the order would not, unless specified, grant general powers to make decisions outside of those powers that are granted by the order. It also happened in this case that the court decided that it was not in XY's interests that the order should be varied to include decisions about social media use, and as those were better made and implemented within the collaborative framework of the Act. The final point about the court's power to make decisions was made on an obiter basis because the question was rendered academic by the determinations on the first two questions. But the court did go through the process of examining the statutes and the statutory language, in essence determined that the court does have the power. It does not cede its power or give it up in order or when it makes orders appointing a deputy, a personal welfare deputy. Can I have the next slide, please? Thank you very much. So here at paragraph 44, deputyship is not merely an amplified voice in discussions, it is a decision-making authority. It is therefore obviously important that the positives are carefully considered by the judge who makes the order and carefully expressed in the order to minimise the scope for misunderstanding. So here is the principle upon which the requirement for specificity and rigour is based. The appointment of a deputy does not confer general authority, as that would be contrary to Parliament's intention of framing the MCA, contrary to the collaborative process underpinning the Act, and contrary to the specific provision at section 14(4), which states that a decision by the court is to be preferred to the appointment of a deputy to make a decision, and the powers conferred on a deputy should be as limited in scope and duration as is reasonably practicable in the circumstances. And bringing back the principle from HDEB and from the first case, Lotson and Motson as well, contrary to the respect for the individual's autonomy. So a success for the LA's minimalist approach over the applicant's maximalist approach to deputyship in that instance. I think that might be my last slide, but can I have the next slide, please, just to see if that's correct? No, it isn't. No, of course, practical guidance. I even flagged it up. Apologies. I foreshadowed it. There it is. Surprise, last slide. Where an application is made for an appointment as deputy, it will always serve the applicant well to consider carefully which decisions they seek to make and to spell that out clearly in the application papers with reasons. Commonly, a direction is made requiring the applicant to file a COP24 statement doing exactly that. Also commonly, the statement received in response fails to do that. So I'm sure a stumbling block that none of us on this call will have tripped over, but one that the court is at pains to emphasise. That last paragraph is what we've already said in the previous paragraph. So I think I will leave it at that, again, unless there's another surprise slide. So I guess next slide, please, and I'll just make sure that I have actually covered all three cases. There we go, fantastic. So I'm going to hand you back over to James, and thank you very much for your time. Also note there's a question in the Q&A. Please do keep those coming in. We'll be keeping an eye on them, and we'll be answering them after James has had his turn to speak. So thank you very much again.
Thank you, Alex, in respect of that summary. In case I'm interested to find out is whether not only have the judgment of His Honour Judge Beckley been appealed, whether either Mr Justice Poole's or Her Honour Judge Hilda's decision also gets appealed. And I think of note, I think in one of those cases there was, I think I don't think it's noted in it, but I think there's been a lot of commentary on it that hopefully they are going to appeal straight to the Court of Appeal and leapfrog the High Court, or I think we will end up in a very similar position we are now, having no kind of authoritative guide on the situation, because we have Mottram and Parr now dealing with the same issues by the same level of judge. So I think that's going to possibly cause even more confusion to us all. Can I have the next slide, please? And there you go. So looking back, and I've been thinking about this more and discussing with people, why are such applications made? And I think those three, I kind of think, are my kind of top three reasons why I think advice comes, people come to seek advice from myself and Pete and others, and I see applications go in and we deal with applications, responding to applications that come into court, is I think there's a key and quite big amount of cases that go in respect of parents and families feeling sidelined by professionals. I know I put the word loss of parental responsibility. I should have probably also put loss of ability to help a loved one who becomes quite unwell later on in life, who hasn't put in place a lasting power of attorney at the point in time. They suddenly start feeling sidelined by professionals. Because professionals, as in the second point, lack, I think, the understanding in respect of how far they should be consulting with people. And I think there was a case, it's not on the slide, but there's a case, Winsphere versus City Hospitals, Sunderland, NHS Foundation Trust back in 2015, and a decision by, I think it was I forgot it, Mr. Justice Blake. And that case, I think, kind of sings factual similarities to the cases that Alex was talking about. That case involved a 20-year-old man, 20-year-old man who had cerebral palsy, epilepsy, spinal deformities, and other associated health conditions, and lacked, therefore, capacity. Everyone accepted that. His mother, who provided a significant amount of care and looking after her son, attended with her son to hospital when he was admitted, and that she remained until 9 o'clock at night in that case. But what happened then overnight, a specialist consultant placed a cardiopulmonary resuscitation should not be attempted notification, or what most people will see as a DNA CPR. That it was accepted on the facts that that case was done without consultation of the mother. It was recorded on it that the mother hadn't been consulted but will be spoken with the following day. And actually, in fact, despite the mother phoning up earlier in that following morning, it wasn't spoken and discussed with her until 12 o'clock the following day. Unfortunately, in that case, they were then subsequently taken off. But what unfortunately happened is that young man didn't actually come out of hospital because he unfortunately passed away. But the case was taken then to the High Court just to reinforce, I think, the point that and does raise this question of lack of understanding, is that it was found that there was a breach of the Human Rights Act, and the judge made it quite clear that Section 4(7) just imposes a duty to consult those identified in the section unless it's not practicable and appropriate to do so. And its active steps must be taken to consult rather than simply passively taking into account views that the decision maker may be aware of. And a point just here is decision maker is the person, in this case, the doctor, or in other cases, will be social workers and so forth. And that and the judge found that failure to comply with that duty will mean that the decision maker cannot rely upon Section 5 of the Mental Capacity Act, for those who should know it, which provides a defence to any decisions that are made in someone's best interest. The interesting point of that case, despite that case being in 2015, the amount of cases still coming 9 years forward when people aren't being consulted, doctors going, we didn't have time to do so, decisions being made without consultation, and still raises quite a big issue with parents and carers in respect of loved ones. And you can see why these applications then are made in such circumstances, because they aren't being consulted, and they believe that by getting the welfare deputyship, they will be listened to more. And there is, I think, antidote. It is accepted and known that doctors sometimes do pay more attention because they know what a deputy is. They know what a lasting power of attorney is. They sometimes don't fully appreciate the level of consultation that needs to take place. And finally, the other point is professionals encourage and or recommend parents and family members to make the applications. That I've seen numerous cases of clients come saying, look, I want a deputyship, social worker says I need it, my doctor says I should need it, this person says I should need it, and so forth, and then the applications come. And I think that's reflected in the case of Lawson of Parr, because that is part of the factual background of how that application then came before Mr. Justice Poole, is that the parents were encouraged by professionals, and when I use professionals, not lawyers, to make the application. Next slide, please. Yes, thank you. Just going to the point, I think I was talking about what professionals should and shouldn't know. I had a bit of a look at what I could find as professional guidance available. And now we can see, look, the British Medical Association has guidance. The fact sheet to GMC has guidance. There's guidance available for health and social care workers about what that they should and shouldn't do. So one of my thoughts was always, is there enough guidance? Because and also, is it fully accurate and up to date? And I think having looked through those, the guidance and the steps that professionals in those circumstances, doctors and social workers and health workers, are given a sufficient guidance and understanding to make sure that they should, in fact, know the approach that needs to be taken when decisions are being made in respect of loved ones. And that I pose at this point the question of why then are issues still being encountered? And it goes to, I think, the difficult situation parents and all of us find ourselves in respect of resources on occasion as well, is that parents want what they believe and we all would accept would be in the best interest, or what their child, the young person, their mother, their father, their brother and sister require, and that they are getting, and they know it's available, and they know that if they had the financial ability to do it independently, that the option would be something available to them. And that what then happens is they seek to challenge those decisions, and they say, look, this isn't in my brother's best interest, my mother's best interest, because look, she needs this, she needs that. And they feel that they aren't, in part on occasion, being listened to. And they believe that it's because they're being, look, it's not your views aren't as important, you aren't the deputy. And actually, sometimes they believe that getting their piece, an order that says they can do so, means that it gives more available options to than when making the decision. But it's not all that. I would also have to accept that decisions are just made because they're failing to consult. So I think it's kind of both ways. Can I have the next slide, please? I always think, and I think it's the most, should there be an exception to how the personal welfare deputies are appointed? That, and when I say should there be an exception, the exception I'm explicitly discussing and just commenting upon, in my view, is in respect of young people who've never had the ability to enter into lasting power of attorneys, advanced decisions, or similar, because, and whether there should be an exception to such, and that covers these cases that I think, the cases that Alex talked of, are a lot of the cases that get challenged in court, go in front of the judges, are the ones with loved ones who have never had the ability to make an active decision to enter into a lasting power of attorney, because and we're all all encouraged now to go, you should have a lasting power of attorney. You don't know when everything will happen. And I wouldn't say, in my views, I think if there was to be ever such an exception, that it should apply to anyone who's ever at any point had capacity. Because I think then it's just your failure to do something that you had the right to do. And that I think there is though, looking at, and as Alex set out the principled case of Lawson, Mottram, Hopton, it explores this issue, I think, in a bit more detail, on the basis that in that case the judge has substantial arguments on all points in respect of, then it went back to the principle of the Mental Capacity Act, and that how the Act is worded in such a way that to protect P and also P's personal autonomy. And I think of note, as was identified in that case, which I agree with, was that the only presumption in the whole of the Mental Capacity Act is that a person must be assumed to have capacity unless it's established that he lacks capacity. There is no any sort of exception included. And I think, whilst I think there should potentially be exceptions, I don't necessarily think it would be right for those exceptions to be identified by a court potentially on the basis that the act was worded in such a particular way and looked at. And I think the other point when looking at the exception and when you were looking at these exceptions is when we are looking at does an extension of parental responsibility result in an overly protective risk inhibiting and therefore risk inhibiting personal development and results in failing to nurture an individual's development. Looking at this point, I think I always have in my mind when doing anything in a court protection, making decisions for someone who can't, and inviting the court to make those decisions is, I think we've all heard the words of Mumby in the case of Westminster City Council and Sykes 2014, which is a big phrase that most of us use, but it says, the final bit I always think is, what good is it making someone safer if it merely makes them miserable? And I think this goes to the point that His Honour Beckley touched upon in his case, is that in certain matters is that people should be able to still make the mistakes. How far should someone who doesn't have capacity have that ability to do it? Go out and do something, go out and have a drink and have a hangover the following morning, or go out and paint something and pick the wrong colour and they paint a room in black and that they need to paint it over, or they go get their hair cut and they sort of like shave their hair off and they go, actually, I don't know why I did this. Like, there is a element that by putting a personal welfare deputy or in respect of people, that you could end up being overly protective and then limiting someone's autonomy. And it's an interesting, I think, debate that I think we can have in respect of level of autonomy. Is that I know Mr. Justice Poole touched upon it in his case, saying that the young person, the par, in that case, that because she has that Ruby has so limited ability to do anything and her own mobility, what autonomy does she have? I think we will probably get some guidance potentially on this point, that autonomy point, potentially when the Supreme Court ever gives its decision in respect of deprivation of liberty points in respect of someone's autonomy, that may be touched upon. But I think sometimes that potentially gives a narrow mind in respect of autonomy for that person, because they are still guided by what their mother, in that case, would think her daughter would want. But unless her mother agrees, she can't do it. So there is that question of finding this point, is there a gap? I would say there's potentially a gap with those that don't have capacity, have never had capacity. There isn't a gap, I would say, because there is sufficient things that people can seek to be put in place, lasting powers of attorney, advanced decisions, and so forth, to assist in making that this is not an issue. And I think they really come to head in cases when someone unexpectedly either loses their capacity, people who've had a car accident, for example, motor vehicle accident, or a young person who was born never having capacity at all. So I think whether there should be an exception is something that I think there's two arguments both ways in respect of this. Can I have my next slide, please? I think dealing with this is quite a straightforward slide. I think most of us, all those on this call or link, will probably know this, but just to repeat that when an application is made, those are the 4 forms that get completed and get sent off to court. They need to be completed, and I think the assessment of capacity needs to be looked at properly when we are doing such, because it is not just the decisions that are being asked need to be made sure they're explicitly addressed in the question of capacity, or it is likely that the matter, either the further evidence will be requested by the court, or you may not get all the decisions you are asking the court to make. So I think the capacity assessment is quite key. I put the point in there, where should an application be made? The rules are quite clear that all applications for personal property welfare get issued at First Avenue House, most 90, probably 5% of the personal welfare deputies are dealt with by one of the judges, whether they're resident or fee paid judges at First Avenue House. The reason I put where should the application be made is that, and I think it is reflective of Alex's cases, potentially. And this is just an observation that Mr. Justice Poole case was a case done up in the northeast, if I get it correct. The two other cases were dealt with by two judges at First Avenue House, and those judges potentially, as I've seen questions put, not questions in this, but commentary in places that and how they've written their judgments, that they are less pragmatic potentially than Mr. Justice Poole, on the basis that of the more level of experience they will have dealt with more of those cases than the cases when they are out of First Avenue House. And that's also reflective in the fact that, as I think I've highlighted here, is that in the case of Parr, there was no need for permission to have been sought in the first place, on the basis that Ruby was under the age of 18, and therefore the exception under Section 50 of the Mental Capacity Act applies, which is that if such person has not reached 18 by anyone who has PR, for him or her can make an application without seeking permission. So you don't have to jump the first hurdle. I also highlight here that there are the other two exceptions when permission is not sought, needs to be sought before an application is made. That is whether there's already an LPA in place, or whether you are a deputy in respect of property and affairs. And that I am aware, from having been sought to advise on matters, that sometimes people apply for the property and affairs first and then apply for the welfare, because they don't have to get permission. I don't think there's any evidence to say that it's more successful that way, but I know that happens. But I also am aware that when looking at rules, that by putting them both in at the same time, you would still have to get permission on both, is my interpretation when I advise on those matters, that you have to get permission on both applications, even if one is looked at first. Next slide, please. Thank you. I will answer some questions at the end. And this is, I think, kind of, it's the final point I make on this. I think this point is, when making applications, I know on the previous slide I identified the 4 forms that have to be filled in. I would always respectfully advise a COP24, a witness statement, is filed at the same time as the application, because I don't think there's a sufficient space on the forms to answer to be able to provide all the information. I think when you are trying to obtain such an order is required. That as identified, I think in the form, I think you would need to detail the specific decisions you want to make. The amount of applications or advice I want to just apply for a deputyship, without, just because they want to be able to make the same sort of welfare decisions as they can, because they are a property and affairs deputy. I think that's not, I'd say, reason why an application needs to be. It needs to be a lot more detailed and specific than that. And I think when I was saying also what specific decisions, it is useful to look at the reasons and explain why the informal process that I think was identified by His Honour Judge Beckley is insufficient and is not sufficient to be able to make the decisions that you were wanting. That when putting applications in, I think my advice is that concrete examples are better than hypothetical examples, on the basis that if someone is concerned something might not happen, or they might not be listened to when the young person or their mother gets to the point of having to move home, or go into a different placement, or a decision may have to be made in the future, and wants to ensure that the applicant and their views are considered, and that I would say is probably not one of the reasons that it is likely from the case law to appear that the courts are going to be particularly sympathetic to that. But then again, it's a kind of a catch-22. If you've got a young person you are seeking 17, 18 with significant needs, and who you are concerned as they transition to adult services, as they transition between children medical services to the adult treatment teams, possibly transfer, move area, and move into different decisions they have to make as they get older, that you don't have concrete examples. And I think you then have the difficult situation of going, do you go, this might happen, wait for the error to happen, which is likely to possibly have a significant impact upon P's best interest or health or well-being, or do you put the application in? And I think this is where it'd be useful when the guidance, if and hopefully when it does go to the Court of Appeal, that guidance is given on this perspective around that very issue. And that I think, as I say here, whether you invite a court to make a time-limited authority, I'm from looking at the authorities that have come out recently, I think that is more likely to be persuasive, not definitively, than if you were seeking an indefinite order on the basis that it just means you have to reapply or extend it. And at that period of time, you will have evidence to support the application for a longer term view. And I think time limited also goes and helps and assists with the question I think Alex touched upon and I mentioned is autonomy, is that there is quite clear, from my professional experience of working with young people, and I think obviously I'll talk to Alex about this after I've finished this slide, is from his perspective of working with people and advising clients in respect of education and so forth, so that the formative years after someone has turned into an adult is sometimes when someone they need their biggest advocate to be advocating and being able to be listened to and coordinating resources. So saying that actually I need an order until a set date in time that makes on the evidence sense, you are possibly going to get more likely support or possibly persuade a judge to grant an authority than going, I just want it now until forever. Because also that goes behind the fact that actually sometimes the deputies are likely to last longer than P, especially if it is not a health condition. There's no life-limiting health condition available. I think the other thing in the orders why you have to be clear in the application is to make sure that you aren't asking for things that you are prohibited from doing. There is a standard personal welfare deputyship order available on templates online, says quite clearly, but also in an act. The act's quite clear, you can't prohibit someone's contact. So if you are asking to be a deputy, you aren't able as the deputy to prohibit a named person from having contact with P. You also aren't able as a deputy to direct a person responsible for P's health and care to allow a different person to treat. You can't make decisions about life-sustaining treatment becomes difficult as well, and also you aren't allowed to agree to restraint unless certain criteria in the Act are satisfied. So that when looking at when advising, when thinking about is the deputyship appropriate or needed, it's always going to see what you are prohibited from doing is useful in respect of that regard as well. That again, the statement of looking at the other points that are left on the slide is that if there has been a delay in applying, the reason why the delay goes back, I think, to the catch-22 point that I was discussing, and most importantly, how the deputy order is in P's best interest and what will it help them with. It's no good saying I think my views will get listened to. I can make sure that I believe I'm being heard. I'm able to be listened to in meetings. I'm able to liaise with professional services to make sure there's a round and multidisciplinary approach. Yes, that might all be factually correct, but why is that needed? for P and P's best interest. And I think that sometimes doesn't, having that explained, is quite key in the applications, and saying it's therefore helps assisting, saying it's not just you wanting to continue parental responsibility for someone. And finally, I think the point of whether an order is more restrictive, the three cases Alex has discussed, I think touch upon those. But I think it's always interesting to go as an example, what's more restrictive? Because technically, depending on how the order is drafted, is that, and what ability as a deputy you're asking to make, you can make decisions on day-to-day care, including diet and dress. That is highly, one might say, highly restrictive. And one says, practically, how does that do? Because you could say, okay, I'm a vegan. If you are a vegan and you want your child says to only eat vegan food, for example, or vegetarian food, then that's a very restrictive. How do we know that is what that young person would ever want? So I think it's putting all our consulting technically on what they're wearing every day, giving an idea what they can wear, and even if you aren't living with them and they're in care by it being cared for away from home, you can make all those decisions. You are the one that makes all those decisions. So it's if looking at it kind of on that perspective, the orders can be very restrictive, and therefore I think that's again being very specific in your applications and in your forms of what you ask for and why, it is quite important. And I think what next was the question. I don't have a slide to this, but I look forward to see where this develops, because and how the Court of Appeal, if or it will get to the Court of Appeal. I believe on the basis of whether it has to go up and then go up again, because I think some guidance is needed on this point, and that it will be interesting to see on the perspectives, I think, of the lived experience and the experience and understanding of the judges who actually hear the appeal on where and how they will approach the issue. Alex, just turning to you from your education perspective and so forth, when you've been advising clients and understanding the difficulties they've encountered, how often do you think a deputy would either have helped or they've been asked and advised to get one?
It's interesting. Obviously, in education, what we see a lot of the time is a need for continuity. So in EHCP proceedings, you often see that a young person approaching adulthood, it can either be extremely wary of the transition from being a child legally to being a young adult and all the changes that might come with that. And their parents, of course, share those anxieties as well, particularly if it's taken them a huge amount of time, as it often has, to get to a position where they're either content or satisfied with the educational provision being made for them. And I think the interesting thing is that you change schemes in technically very quickly, obviously on a dime, basically, the day that a young person achieves the age of maturity. And with that potentially comes an enormous amount of change, when at a time when actually what they really need is a very, very carefully planned, gradual movement toward a different stage in their life, that successful transition to adulthood, which can be so easily impaired. And so what I would say is actually, I think education practitioners don't often enough think about the question of deputyship, particularly when they're coming across young people who might lack capacity or who have already been found to lack capacity in some way in their education work and community care work as well, and are thinking about how to provide holistic advice to families who are seeking to address either pending or ongoing transition from childhood to adulthood. And it's something that I think if you're hoping to offer a holistic set of advice to people, it's something that should be borne in mind potentially, perhaps more. Certainly, I'd say put my hand up and say from my perspective, and I think probably from other practitioners' perspective as well.
Yes, and I think that's the tension, isn't it? It's like how transitioning at that point also, you have the natural change in social workers generally, new people who don't know ins and outs. And that I assume my experience I've seen when I've looked at cases in the sense of advice on what further evidence they need, you also have the issue is that even if they're named on forms to be consulted, that's not necessarily has given my clients any sort of reassurance. Have you ever had similar experiences?
Well, I think the interesting point about that is that it comes up in par, doesn't it? Is that here's the problem I think some parents find when they're approaching adulthood, and particularly potentially considering an application for deputyship, especially if they've been through the system for a long period of time, which a lot of them will have done, is a lot of them feel like they're at war with professionals around them, rightly or wrongly. They feel like their job has been to be the squeaky wheel and get the grease for their young person, particularly where systems are stretched. And obviously, what Parr says is what part of the judgment was that Mrs. Parr was able to work collaboratively, and that was to her benefit and a point that weighed in favour of granting the application for her to be appointed as deputy. But the balance for so many people, or not even the balance, I think for some people actually that choice just hasn't been there through the years of what is always going to be really difficult relationship building with the statutory professionals around you, often involving a lot of contentious and difficult disagreements, particularly where there are incentives, frankly, and I think we have to speak honestly, other than best interest of the young person at all times, have come into play that they haven't been able to maintain that relationship. And so that's going to weigh against them when they come to make an application for deputyship, and rightly or wrongly, and potentially, it's going to be that that the court has to consider that. Particularly, take for example the young person I had recently who, the local authority had to put in place provision to limit or regulate their mode of communication with the local authority. How can they engage in the collaborative framework envisioned in the Act if they're only allowed one call per week and they're only allowed that call to go through to a particular line, and they speak with that one person, and then obviously you're expecting that piece of information they relay during those regulated calls to then sort of disseminate out to the proper professionals. It's extremely difficult to way of incentivizing a certain kind of behavior.
And I think touching on what you're saying, I think that's also, I assume, when you can see in the authorities a bit of a tension the judges have is very much of just because you have an order doesn't mean you're going to be listened to necessarily any more than if you don't. And I think from experience in not necessarily deputies necessarily, also like people who have lasting power of attorneys, that they feel that they have to be listened to. And I think that you can see in cases when there are challenges at lasting power of attorneys, which I think would say apply as much to deputyship, is that you can see the tension going, just because you have the paper doesn't mean you can be unreasonable as a person. You still have to act professionally. And I think there's a tension there. And I always wonder whether when judges are being asked to make orders, when you are putting applications in, if you say, look, even if I'm not granted it, can I have something on the order that says I should be listened to? Because professionals all they see is a court order with a or saying I have to consult this person. So I feel like sometimes potentially some people think there's a way around it, but I think doesn't really get around the issue of not lack of consulting is my perspective there. That I think there's questioning which I'll deal with. Is I was asked a question in respect of if you are concerned in respect of a young person who is engaging with activities that are contrary to their interests, and whether a deputyship is the correct. And I think that I think is not necessarily a reason necessarily to be a deputy, on the basis that you could still make a decision that they're not allowed to do that. But then it gets to the point of restrictions, supervision, and that. Therefore, it really ends up being a question of deprivation of liberty, again, which would require the court to make a decision in respect of that regard. And I think that's quite an interesting, useful question. Alex, whether you have any comments on this, is that if you become the decision maker as a deputy, you are sometimes asked to make very complex, important decisions for the P, and a lot of some of these deputies don't have that understanding and experience that people would always have if you're a lay deputy. Do you agree with that? Have any comments upon that?
It's difficult, isn't it? Because it's part of a system, I think, that we've seen in the cases that we've covered today, where there's obviously like huge tension between big ideas about how the system should work, and we're bringing people, giving them formal and court-appointed positions, which are really important and can play a really vital and important role, and a role that can't be replaced by professionals. And we often say in Sen, you often hear tribunal judges say that no one is more expert in their children than the parents. That they are experts in their children, and that doesn't change when they get to adulthood. But they also don't have the professional experience and necessary and are potentially being thrust into a role for which um, it doesn't come with the a package of training in order to get up to speed and be able to discharge it in a way that the courts would expect them to. And there's certainly a tension there, I think.
Yes, and you see, so the cases, and I think your experience, our experience in other things outside of court of protection is very much it requires potentially challenges on other routes. The deputyship doesn't give you the ability to override that, whether that is appealing an education decision, appealing a health-related healthcare budget, continuing a healthcare plan, or just what the resources are available to an adult in the community. They will encounter the same difficulty. The only difference is that their decision has to be afforded the respect it does as a deputy. So I agree. Sometimes it's not an answer. You still get the same problem, and I wonder whether, and we'll never know, is in that case, in Ruby's case, and Parr, and all the other cases you read, is that does that person on the ground position change practically when they have that piece of paper that says they're a deputy, or are they still encountering the problems and fighting and advocating for that young person that they've always had to in any event? It's something I think kind of an interest question. If anyone's got any questions, please don't hesitate to put them in the Q&A, and we will answer them if there's anything at all. But I think my takeaway from the position at the moment is gladly we now have 2 or 3 cases that have come in at the same time that have been reported, which may end up being some sort of more guidance or some clarity, because I do know that the Parr case has resulted in a greater number of applications being made, because Miss Ruby's mum's position is not unique, and there's lots of young people I hear have always wanted and seek advice and guidance on what to do in such cases. So I even think even when authority do come in, there will be plenty of decisions that need to be made in respect of this. Can I go to my last slide, please? I would like to thank everyone who came and listened to myself and Alex and discuss this evening this question of personal welfare deputyship, what next, and the impact of the cases that have recently come out. You've heard some practical guidance and tips and issues that need to be addressed when making such applications to the court to think about, and because these questions are the questions that go through the judge's mind and say, why can't other alternatives work? And I think myself and Alex had identified that this is still an area that work needs to be done, maybe outside the court of protection on other areas, but we will see what happens to Court of Appeal. So I would like to say thank you to everyone who attended. The slides will be made available, as will the recording, at the once this is concluded. Alex, any final words?
No, I think that's been really productive. So thank you so much. And thank you again to everyone who's joined. It's been great to be able to speak with you tonight.
Thank you.